The dispute over wages in the public sector is continuing. Members of the National Education, Health and Allied Workers Union protested at the union buildings in Pretoria yesterday. For months, NEHAWU has been demanding that a 2018 wage increase agreement between workers and government be implemented with immediate effect. However, government is asked to review the last leg of the 3-year pay agreement, saying it just does not have the money. To discuss the practicality of the agreement amid the country's current finances, as well as in terms of what the law actually says, we're joined by Magate Phala, who is a labour law specialist. Magate, great to have you. Thanks for being with us this morning.
Hi, good morning, Leanne, and to your listeners at home.
I'm so glad that we can actually get now into the law and what it says around this. So, when an employer and an employee, and the unions in this case, decide on a 3-year agreement, how binding is this? And obviously you've looked at this agreement between government and the unions. How binding is it?
Well, thanks very much, Leanne. Look, the agreement is binding as it stands now. And you are correct, it is for the period of 3 years. In other words, it became effective on the 1st of April 2018 to 2019, 1st of April 2019 to 2020, and 1st of April 2020, and it should end on the 31st of March 2021. So, as it stands, the agreement is binding to both parties. In other words, when I say parties, I mean the state as the employer, and the parties, I mean the unions, trade unions that are, party to the PSCBC as a bargaining council.
Yeah.
So as the agreements, as matters stand now, the agreement is binding.
Yeah. So what argument does government have? Because they're saying they just don't have the money to go ahead and do these increases across the board.
Look, Leanne, really, let me put it this way. Firstly, as we speak now, there is a labor court application by government or national treasury to try and set aside this agreement. And now, if you look at clause 10 or section 10 of this agreement, it says for dispute resolution mechanism that may be used in the event that there is an issue around the interpretation and application of the provisions of this agreement. Such dispute should be referred to the bargaining council, which is the PSCBC in this regard. And now, what the government is doing is actually the opposite of what clause 10 provides in this agreement. And, say for instance, this agreement is successfully set aside at the labor court. I can tell you that this is going to be a very serious setback to the concept of collective bargaining itself, because collective bargaining, or collective agreements are a product of a collective bargaining process. So now, if any party at the end of the day, or if any party enters into an agreement and at the end of the day or later reneges from that agreement, it actually borders on trust, whether or not such party can be trusted in future. So it will actually cause problems insofar as trust is concerned.
Yeah, and this is one of the big things, because this is exactly what they've spoken to, the unions in particular, talking to the missing billions, to the amount of money that has unfortunately just disappeared with corruption. And they really are using the whole PPE scandal as a big basis of their argument. And they seem to be adamant, they are adamant, especially now, that hundreds of health workers have actually died from COVID-19. And this is in the background of the corruption and the PPE scandals. So let's have a look at this now. And this, of course, making the situation worse for the workers on the ground, and government saying they don't have the money, but so much money has just disappeared due to corruption.
Yes, and you know, workers are, or union representatives are not blind. I mean, every day there is an issue about corruption. You know, the impact of corruption that occurs in the state and all of that. And later you want to come and say, you know, you don't have money, but you know that is a separate issue. Here we are talking about a collective agreement. That is the when we talk about a collective agreement, we talk about a negotiated resolution, between parties that has been entered into voluntarily and mutually between parties. So now, if you come and say, no, we want to set aside this agreement because it is invalid, it is unconstitutional, it cannot be enforced. Really, what do you mean? I mean, this is something that has been negotiated over a period of time, why did they enter into a 3-year agreement if really they could not predict the future? So I think those are my concerns, and my other concern is why now bypass the council, of which, as I have referred to earlier, that clause 10 says that if there is any dispute around the interpretation or application of this agreement, then this matter should be referred back to the bargaining council. So now you bypass that process. So now that this is in breach of the agreement itself, and that's why I'm saying, it is really a serious concern insofar as the whole collective bargaining process is concerned. And just to add that, collective bargaining is not necessarily about, negotiating, salary increases or salary adjustments. You also negotiate. There are other important day-to-day matters there. So that have to be negotiated, in future and going forward. So this will actually impact the entire process. And maybe just also to add there, Leanne, that in the absence of a collective agreement, employees do not necessarily have an automatic right to salary increases. This is something that should be negotiated. But once you have a collective agreement, then it becomes a right. It becomes an entitlement to these employees.
Yeah, indeed, because as you mentioned in the very first answer, this is a binding agreement. However, we did see towards the end of last month, the end of August, we saw that government actually went as far as, the department, that's the Public Service and Administration Ministry, going as far as the Constitutional Court to try and actually ensure that this agreement is actually, the wage agreement is declared unconstitutional. And this, of course, delayed the whole process. What do you make of that?
No, as I'm saying, the matter is actually before the Labour Court to try and set aside the collective agreement. Well, the first round, the government actually lost, trying to interdict the arbitration proceeding, which were taking place at the bargaining council. But, the commissioner, sort of postponed the matter sine die, pending the outcome of the current challenge, which is actually about whether or not this agreement is invalid and unconstitutional, or whether or not it can be enforced. So really, I have personally, I have a serious concern about that, because if you look from ILO perspective, the International Labour Organization, the ILO Convention 154 of 1981, which talks about promoting, collective, bargaining. It emphasizes the principle of trust, that this process should be built on trust. So and trust is everything. Because forget about wage agreement and going forward. What will this do to the whole process of collective agreement? Will, if the state in future want to, as the employer want to put issues forward, other matters that impact on the terms and conditions of employees, they want to put them forward on the agenda and say, come, let's negotiate around this, let's deliberate on these issues. What will that do to the trade unions? What will that do to the other, members of the council?
Yeah.
So it's a problem. It's a problem. I think they should have, handled it differently. Other than trying to, now undermine this agreement and say it should be set aside. It is invalid. It is unconstitutional. Whereas, this was entered into voluntarily, mutually. It's a mutual agreement.
Indeed,
it was
indeed.
negotiated for a period of time.
Let's have a look at the issue that, and let's take a look at it from government side. We've looked at it from the union side, and we understand that this is a binding agreement that the front line of all of this are the workers that are certainly worthy of getting this salary increase between 6 and 8%, as what has been said. I mean, we're talking to doctors and nurses and teachers, and you name it. These are the ones that are being most affected. But from a realistic point of view, nobody could foresee this pandemic that has come and hit South Africa in a very, very bad way. We've seen the numbers. We've seen how the economy has taken a big hammering. From a practical point of view and for the legal side of things, if government truly cannot afford to pay these salary increases, what then? What happens?
That's why I'm saying, Leanne, it still goes back to what I've said earlier. Why not go back to the council? Why not meet parties in good faith and be transparent to those parties? Because yes, that is a valid argument. But I'm saying, go back to the parties, go back to the table, and deliberate these issues in good faith, in good spirit, and show the realistic part of it. To say, look, realistically speaking, we cannot be able to implement this. But to try and sort of now overlook, that process that has been set there, it is a serious concern for me.
Yeah, which is what's unfortunately be happening. We've seen the union marching yesterday. This was NEHAWU to the union buildings. I beg your pardon, this was on Monday. I don't even know what day we're on. Yes, that was yesterday. And they handed over the memorandum to Jackson Mthembu, in the presidency, and basically saying that the president would meet on Wednesday. He's not well at the moment, but they had already handed a memorandum 2 weeks ago where they had basically said, we demand that this be implemented with immediate effect. So we're hoping that the president will actually, even though he's not well, still follow through on his promise to meet unions tomorrow and discuss exactly what you're saying and actually be open and transparent.
Yes, and exactly, because like I'm saying, collective or sound labor relations, let me put it that way, it's not necessarily about wage negotiations. This is, wage negotiations are seasonal, but you have day-to-day employee-employer issues that you still need those parties. Now, if you are going to try and circumvent the process and use go to the other forums and try to undermine the process that has been set there, it is really going to be a problem for them if they don't amicably and then in good spirit, in good faith, try and look into this issue. And go back to clause 10. It says, if there is any issue around the interpretation or application of this agreement, which is Resolution 1 of 2018, they need to go back to the PSCPC, which is the bargaining council, and look at the issues and see how they can actually resolve this matter. Other than the court and saying, let's set that aside the agreement. Like I'm saying, let's say it is successfully set aside. That will do a serious damage to the labor relations in the public service.
All right, Magate, we'll leave it there for this morning. Magate Phala, who is a labour law specialist, talking to us about the wage dispute that's happening between government and public servants. Of course, behind all of this is the threat of an absolute shutdown. And also remember that at the beginning, this was the COSATU-affiliated unions that were leading the charge. But now it's also the other trade unions that are not affiliated to COSATU have also joined in. And there's this mass shutdown that's been threatened. So we'll have to watch on this one very, very closely. All right, it's 7 o'clock.